enforcement of the deadlines. Second, I would increase the staff complement of the different salas so that there will be more bodies to do the research work and assist the judge in disposing the cases speedily.
But that solution might take years to happen because you will have to contend with the rules of the civil service. If you want to increase the personnel of an office in government, the Supreme Court has just increased the number of employees. You will have to contend with the rules of the civil service.
Then can we not hire?
You will have to go to Congress for additional budget.
Then
you will have to justify to the executive, to the Department of Justice, that Department of Budget, that you need this amount.
Then I would liaise with the executive and the legislative branches in order to precisely to implement that proposal.
Anyway, that's a long-term solution. Yes. I'm talking about short-term solutions in order to reduce the backlog of the cases in the lower courts.
And fill up the vacancies.
Mm-hmm.
And probably hire interns.
Mm-hmm. Hire?
If we could not immediately hire permanent clerks or researchers. But the thing is, we must fill up the vacancies because it's intolerable that the vacancies is at 25%.
What is your position in the adoption of rules to the effect that instead of an oral testimony of witnesses, the witnesses' testimony shall be in affidavit form, which we sometimes call judicial affidavits. Are you in favor of the use of judicial affidavits?
I am in favor of that use, provided that there's an ability to cross-examine the
Of course, the other party will have to cross-examine. But there are some resistance, or there are resistances rather, because if you do that, especially in criminal cases, judges will not be able to determine the demeanor of the witness. And one way of determining the demeanor of a witness is the credibility of the witness is the demeanor of the witness when he takes the witness stand.
I think that the determination of the demeanor of the witness might come during the cross-examination.
Well, but if you allow a judicial affidavit, you can just imagine that if the judicial affidavit is prepared by the counsel, of course it will be the best judicial affidavit. It will be the best affidavit because practically the witness is already taught what to say. Unlike when the testimony of the witness is made orally, and I am referring to direct examination, where the case is developed through the questions and answers. And you can also, it's also needed, I mean, you can determine the demeanor of the witness, therefore, not only on cross-examination, but likewise on direct examination.
Yes, you are articulating the possible drawback of the proposal.
That's why, no, it was a follow-up question because according to you, the demeanor of the witness may be determined through the cross-examination. But what I'm saying also is that you can also determine the demeanor of the witness on direct examination.
Of course.
So what is your position now? You are in favor of judicial affidavit?
Well, I thought that you were proposing it as a means to accelerate cases.
Yeah, no, I'm asking if you're in favor of a judicial affidavit instead of a direct examination in order to expedite cases.
I'm inclined to favor to some extent. Yeah.
What about amendment of the rules of court? Are you proposing the amendment of the rules of court in order to expedite cases? Because I think if I heard you right, you were saying that you will be strict on the periods within which to terminate a case. Did I get you right?
Yes.
Yeah. But we have already periods under the rules.
It's a matter of implementing it strictly.
You want that it be strictly implemented?
Yeah.
Now, aside from the strict implementation of the periods provided for by the rules and other laws, what What else do you suggest?
It's probably good to remove technical requirements.
Technical, like what?
Like, for instance, if there are defects in the verification or in the
Oh, you're referring to initiatory pleadings, probably complaints. You are
yeah, well,
referring-
then if
you're
there's a
referring-
defect in the verification or similar things, that judges should not be strict.
But if you know, just for your information, in the data submitted by, presented by Dean Bautista yesterday, the disposal rating of the Supreme Court is high. I think it's something like 60%. The disposal rating of the Court of Appeals, likewise, is possible, no? But the disposal rating of the Sandigan Bayan, the lower courts, is low. Probably the reason is that the Court of Appeals and the Supreme Court are not trier of facts. In other words, they are not trial courts.
All right.
We resolve cases based on the pleadings, no? Also in the Court of Appeals, they resolve cases based on the pleadings. But in the lower courts, before they could decide cases, they will have to hear the cases.
Yes.
Also in the Sandigan Bayan, because in Sandigan Bayan, it's a unique court. It is an appellate court because the cases that are decided by the lower courts, insofar as commission of crimes by public official, go to the Sandigan Bayan on appeal. But they have also original jurisdiction. They hear cases. And the backlog of cases, I think, is attributable to the long process of presentation of evidence, which means trial. Do you agree? Tony, do you agree on that? In your practice of law, do you agree that there is really delay in the cases before trial courts? Do you agree?
That's right.
So aside from judicial affidavits and aside from strict adherence to the periods within which to resolve cases, what proposal?
Well, continuous trials.
Continuous trial. We have also that in the rules. Under the speedy trial, continuous trial.
But not strictly implemented.
What about the pretrial rule? Is the pretrial rule an effective measure of expediting the termination of cases?
Yes, of course.
Of course.
Yes.
Yeah. As a practitioner, have you appeared before judges, and have you observed them strictly following the provisions of the rules on pretrial?
Not in the recent past.
Oh. But even when you were a new lawyer, there was already a rule on pretrial.
Yes, that's
Yeah,
right.
yeah.
Yes.
Now, there is also a question from the Twitter. Oh, before I go to that, yeah, this comes from the Twitter, but because of that question, I'm reminded of that case, the one that you mentioned about Salvacion versus Central Bank.
All right.
That is a decision regarding the interpretation of the Foreign Currency Development, Deposit Act.
Yes.
Whether or not dollar deposit can be opened, considering the fact that there is an absolute confidentiality, and it can only be opened through the consent of the depositor.
Yes.
Is that right?
Yes.
Yeah. But in Salvacion, according to you, the court required the opening of the foreign deposit.
It's the garnishment.
The garnishment,
Yes.
yeah, it allowed the garnishment.
Yes.
Because of that civil liability awarded by the court in a rape case.
Yes.
Because you could not probably anymore, because there was no way to enforce the damages awarded by the court, if not through this deposit.
Yes. Yes.
But you agree with me that that case is merely pro hac vice.
Yes, it's pro hac vice.
Only for that case.
Only for that.
Only for that case.
That's right.
Not in other cases, no?
Not in other cases.
Now, there is another question here, no? Should retired Supreme Court justices accept directorships in corporations who are involved in cases they previously decided?
I would not do that personally. Yeah.
What do you mean you do not do that?
I would refrain from accepting directorship after my retirement.
Yeah, even because under the law, I remember under 6713, you're not supposed to accept positions positions in institutions where those institutions had cases before the court within a period of 1 year. I think that's the provision.
That's right. But even after 1 year,
under Republic Act 6713, it is indeed prohibited within the 1 year period. Okay? Beyond that 1 year period, if you were now a retired as a justice, would you accept?
I would not accept.
Definitely.
Definitely, I would just go to teaching.
You will
Go back to teaching.
you will be content with a pension, probably of a small amount.
Yes, but I have
From the
more
Supreme
than
Court?
savings from my law practice, so money is not an issue.
So because you already earn a lot so you already earn a lot in the practice of law, there is no need to go back.
Yes, sir.
Yeah. Okay. Not even your law office, you will not go back as an off counsel.
No
No more.
more.
Now, my last question is, because of your background, Attorney Morales, you've been representing probably big businesses, no, paying high fees, and private individuals paying high fees, no. In other words, your practice is quite lucrative, no.
Yes, sir.
You're lucrative. And you now become the Chief Justice. Now, I'm just wondering, how would you lead and deal with 14, because you're coming from the outside, 14 experienced justices. Because if I use the word learned, my question might be biased because I'm included, no? So let's assume that experienced 14 justices, and you're coming from the outside.
I would, as I said earlier, I would approach each and every justice and appeal to their sense of patriotism, appeal to them to extend their cooperation to me in the interest of country and the judicial system.
Okay, last question. What is your edge over incumbent justices?
I bring fresh and impartial approach to the judicial process.
So those incompetent justices are no longer fresh.
I'm not saying that.
Okay. On that note, I'm true. Thank you, Attorney Morales.